Good evening, Julie.
Good evening, Mr. Sharp, and good evening all. We are here to listen to Jon's wisdom and expertise on project security and guarantees with Mr. Jon Sharp. As always, if you could pop any questions into the Q&A question tool on the bottom toolbar, and Jon will endeavour to answer these for you at the end. And as always, if you have any specific queries you don't necessarily want to raise during the presentation, Jon can be reached on jonsharp@silverllp.com. So without any further ado, Mr. Sharp, the floor is yours.
Thank you, Julie. Good evening, ladies and gentlemen. Project security. Everyone wants to make sure that they get paid for the jobs that they're doing. So this is hopefully a useful summary of what the position is and what you can do to hopefully ensure that you do get paid for the work that you're doing. That's me. Less said about him, the better. Details are all on the website. But please, as Julie said, if you've got any direct questions, then please don't hesitate to contact me. I'll be very happy to answer them. Agenda for today: the need for security in construction contracts. So why? Design liabilities, standard form contracts, key provisions and mechanisms, common problems, third-party rights, collateral warranties and bonds. Contracts are always, well, contract terms are always difficult to understand, but there is one basic rule that's been established for some considerable period of time, and that's the rule of privity of contract. Set out very accurately in Dunlop Pneumatic Tyre Company against Selfridge & Co. Limited, 1915, an old case. This is a fundamental tenet of English law. Only parties to a contract can sue on that contract. Classic example is that if I enter into a contract with a company that's going to supply me with some goods and materials and they don't do it, I can sue them. However, my neighbour next door can't do it because he's not a party to the contract. So the doctrine protects parties to contracts against claims from randomers, strangers. And there are commonly times when the parties to the contract expressly agree that some other entity is entitled to that benefit. So, classic example is under the JCT Design and Build Contracts 2016. It stated that other than such rights of any purchasers, tenants and or funder as take effect pursuant to clauses 7A and or 7B, nothing in this contract confers or is tended to confer any right to enforce any of its terms on any party who is not a party to it. So the contract itself has allowed some other parties who are not directly parties to it, excuse me, to have some rights, at least, under the contract. Now, normally in most contracts, there's only two parties to a contract, possibly three, possibly four. But JCT and building contracts generally are slightly different because there's multiple parties involved. So, everybody in this slide could potentially have a right of action against everybody else because they will have been given some rights under JCT contracts. Same here. And same there. It's always surprised me that there are so many parties involved in JCT contracts. It's a bit like transportation contracts. you're trying to ship a piece of equipment from Scotland to Turkey, there are at least 4 different sets of contracts involved, and there's multiple parties involved in those contracts. Unfortunately, we're in the same position with JCT. Design liabilities. Standard Build Contract 2016. Intermediate Contracts with Design 2016. And Minor Works Design are not design and build contracts. They are only suitable where the contractor is to be responsible for a discrete element of the design. JCT, SBC, ICD and MWD 2016. In completing the design for the works, the contractor is not required to take responsibility either for the contents of any employer's requirements or for verifying the accuracy of any design contained in the employer's requirements. That's JCT, SBC, clause 2.13. Now, the above provision appears to have been intended to counter the possible implications of a 2002 case called Cooperative Insurance Society Limited against Henry Boot Scotland Limited, where it was held that a contractor required to complete design work was under a duty of care to examine an employer's pre-existing design and to satisfy himself that this was such that would produce a completed design that could be built. Well, I'm sure that's entirely fair. However, under JCT, under SBC 2016, DB 2016, ICD 2016, but not MW 2016, a contractor is obliged to notify any inadequacies in the employer's requirements on becoming aware of them and seek reimbursement by way of a variation. So an extension in order to put right the employer's requirements if they are defective. Plus, it is incumbent on the contractor to ensure the employer's design complies with statutory requirements, except in DB 2016, where the ER state that they are so compliant. Now, it's open to employers to delete, amend the above provisions, and this is also a common amendment. Employers will commonly seek a chain of amendments to the recitals and to the above provisions to reverse this allocation of risk, namely to make the contractor responsible entirely for the design contained in the employer's requirements. The contractor is required to undertake any design work to the standard expected of an appropriate professional consultant, such as an architect or consulting engineer appointed directly by the employer and not undertaking any construction work. Now, ladies and gentlemen, contractual provisions are very, very important. JCT contracts are, for the most part, fired, if you'll pardon the expression, willy-nilly amongst all parties, and in the rush to sign them, many parties don't read them correctly. Indeed, with respect to the construction industry, you are amongst the world's worst at doing this. You scribble notes on side things which neither party signs. Half the time, you don't actually even sign the documentation. in its final form, and you all sort of agree with a few emails that, well, we'll amend that, we'll amend this, and we'll amend that. Unfortunately, when it comes to court proceedings, if it does come to that, or indeed an adjudication, contracts are important. And I keep stressing, and I've stressed before, and I'm probably getting very boring now, that you should ensure that the contractual arrangements that you make between each other are correct and accurate and reflect the intentions of you both. If you are going to, in the rush of time, amend JCT contracts, then please, it would help every lawyer, not me, every lawyer in this country, if you wrote clearly. That would be a good start. And then if you could sign the amendments, that would also be very good. So both parties who agree to that particular amendment. Okay? So contracts are important. Courts only look at what you have agreed between the two of you pursuant to the only contract that they have. So please take time to read through the contracts. JCT SPC 2016 contractors design documents. These are defined in the contract as the drawings, details and specifications of materials, goods and workmanship and other related documents prepared by or for the contractor in relation to the contractor's design portion. The contractor's design submission procedure is set out in Schedule 1. It sets out a submission approval and communication system in relation to the contractor's design document. This procedure and the employer's involvement in it does not affect the contractor's liability for design. Again, seems rather unfair, but that's what the documentation and the contract says. Standard form contracts, key provisions and mechanisms. At common law, a contract will generally be construed as a whole, i.e., the conditions and documents will be read together. Absolutely right. If you are going to amend documentation, firstly, you should be amending the main contract with both parties signing, not only the amendments, but the full contract. And if you are going to attach documentation to a contract, please make sure that it is actually attached. Staplers had a purpose in life, and that was to staple all documents together. Don't enter into a contract which refers to an annex that's not there, that doesn't exist. There may have existed once, but has subsequently been changed because you've changed your minds. Make sure when you sign documentation, it is complete in its entirety, and there is one contract. Because where there is ambiguity, the courts, with common law and case law, have developed certain principles which they apply as an aid to interpretation. The courts shouldn't have to interpret contracts. They should be complete in one document with its attachments and with everyone signing it. Now, there may be a provision within the contract that the court doesn't quite understand. That's fine. You can ask the court to say, look, I'm not quite sure, given the factual scenario surrounding this contract, what this means. But that's a short application to the court under what's called Part 8 procedure. You can say to the court, look, we've agreed on everything else, but we've just got this one little problem here. What you shouldn't be asking the courts to do is interpret the entirety of a contract, because it should be absolutely clear to the court from the start what it is. But the courts do have this interpretation procedure. And the first one is that there is a rule of construction that greater weight should be given to conditions that have been specifically drafted against those which are of a standard nature. Absolutely correct. So if you have agreed a specific provision which is outside, for example, JCT normal provisions, the courts will give more weight to that than a standard provision within the JCT contract. Now, there are some contracts that try and get round that and say, no, this is the standard form of contract, nothing else that's agreed. Sorry, no, it's still the standard terms. So you need to be very specific in your drafting in relation to that. But the general rule, handwritten, yes, is preferred over typewritten or over printed. So if you have made handwritten amendments, perfectly understandable. Pressure to get in a tender, for example, etc. Just make sure both parties try and sign them. Difficult, I accept entirely in our current circumstances, but at least there should be, I would say at the moment, an exchange of emails between parties referring to the specific provisions and agreeing to any handwritten amendments that one party's made. So, someone sends a contract in and says, John, I'm sorry, I've amended that. Can you see in the email below my amendment to paragraph 5? Do you agree that? Yes. I go back and say, that's fine. That's what we discussed. It's agreed. Then that's fine. However, there are a hierarchy of documents, including common amendments to the standard form. So sometimes you will get some documentation that the common amendments sort of supersede the standard form. So the standard form of documents, but everyone amends that clause. Sometimes that can be taken into account by the courts. But handwritten, over typewritten, over printed. Now, common problems. Errors and inadequacy in the contract bill and CPD documents. Well, yes, I'm afraid to say that happens a great deal of the time. Without wishing to preach or whatever, yeah, you're not very good, generally, as a construction industry, at getting the documentation right at the start. In and between documents generally, yes, well, we've seen some horror stories over the years, I can assure you of that, where one party signed a document and another party signed a completely different document, for example. That's not really a contract. Well, what were you doing? And in between the documents related to CPD, well, yes, you know, not good. Then a recipe for disaster. Now, with respect, I'm not trying to lecture anyone here at all. Commercial pressures are commercial pressures, and we need to get on with it. But I'm just simply trying to say we can delay that process for a couple of hours while someone actually gets together all of the construction documentation in one form. It's going to save you an awful lot of money in adjudication costs or in court costs. We also get 2 versions of drawing revisions of the wrong version signed. Not helpful. Doesn't help anyone, really. What were we supposed to be designing? Oh, I don't know. Contract drawings list does not correspond with the drawings signed. Yeah, we've had that on 2 or 3 occasions now. Again, not good. A little bit of half an hour extra, possibly, to get it all matching up would have saved these people an awful lot of money. Failure to complete the contractual documents, so no one signs them. There's no point in trying to execute documentation under the terms of a deed if nobody's actually signed and witnessed the deed. It doesn't work. And failure to complete the formalities. Yeah, if you want to have a deed and to enter a contract as a deed, you have to have certain formalities, witnesses, etc. So please take care when drafting your contracts. Make sure you've read the contracts and accept that times are difficult at the moment, and face-to-face meetings are rare, but clear email exchanges, excuse me, regarding amendments to the fundamental documentation are always a good thing to do. And I suspect the courts would regard as the best evidence of mutual agreement that we can do at the moment. Now, third parties may achieve entitlement to an enforceable benefit through either of two routes provided by Section 1 and Section 2 of CRTPA, where the contract expressly states they may enforce the term in their own right. That's common. Again, beware of third-party rights. Make sure, and there are certain circumstances where you may want a third party to have rights, that you understand what they are. And where the terms of the contract purport to confer benefits on them, provided in Section 1(2), then it cannot be construed in a proper construction. The parties to the contract do not intend the term to be enforceable by others. So be careful. When you're dealing with third-party rights, you don't want them to have any more than they're absolutely entitled to. Section 1(3) provides that third parties may be identified by name as a member of a class, so subcontractors. How much right do you want your subcontractors to have under the terms of your main contract? All of them? None of them? Some of them? A bit of them? But make sure you know what it is you're giving your subcontractors rights to. And by description, they need not be in existence when the contract was entered into. Absolutely right. You may decide during the time of your contractual arrangements between the two main parties that you do want subcontractors involved. That's fine. You can add them to the contract, provided that they consent and that both parties to the main contract also consent. How do parties enforce such a provision? Well, Section 1(5) gives the qualifying third party the same remedies as he would as if he were a party to the contract. So he can stand in the shoes of both of the main contracting parties. That's why you need to be very careful about what third party rights you're going to grant. My view is that you should start from, well, which ones do I have to give? Which ones are, if I don't give them, are not, this contract's not going to work. Start from that position and then work down would be the best advice I could give. Also, it's provided by way of notice between the parties to the contract that rights will be conferred upon the other party. So you do decide that you're going to add subcontractors. It may be that you want to make sure that you can attach them a bit more liability in terms of their work. But if you're going to do that, you need to make sure that all parties to the contract are aware that they have been added and everybody else can look at them and see what you have. Third-party rights for purchasers and tenants. Under JCT, these rights and limitations are set out in Chapter 5, Part 1. They include rights granted by the contractor as being works to comply with the contracting good practice, the contractor's liability, no rights to take instructions, use of contractor's design documents, professional indemnity insurance, assignment, giving of notices, and enforcement of rights. Third-party rights for any funders. These rights and limitations are set out under Schedule 5, Part 2. Note the differences in this respect. No rights are granted by the employer except acknowledgement where the funder exercises step-in rights. They include rights granted by the contractor as being works to comply with the contractable practice, the contractor's liability, no rights to take instructions unless he steps into the place of the employer, step-in rights, the most significant difference, use of contractor's design documents, professional indemnity insurance again, assignment, giving him notices, and enforcement of rights. Now, collateral warranties. The employer may want the contractor to grant right to purchasers, tenants, and the funder, but by way of a collateral warranty, clauses 7C and 7D. Similarly, they may want all the same beneficiaries to benefit from rights granted by subcontractors under clause 7E. The collateral warranty is no more, and this is important, than an obligation to enter into a separate agreement under specified terms. This to date is the most common and tends to cause the majority of problems. Whilst it's triggered within the contract particulars, the procurement and delivery of such agreements can lead to very difficult processes. The promise given by the contractor in the warranty is given as at practical completion. So the request can be made up to and following practical completion. Most in the industry, and I'm sure you all do, understand the difficulty in procurement if the contractor or any other party does not enter into the required warranty, and clearly no benefit can be enforced. So make sure your warranties, your guarantees, etc. are all signed up. Under most standard forms, there are no sanctions on the contract for failing to comply with the employer's notice. There aren't. So you're going to go to court or to adjudication, all of which is costly. So what's the solution? Well, TPR versus collateral warranties, enforcement, ease of obtaining, reduction of administration habits, including step-in rights for the funder. So, do you need a bond? Well, there's various different types of bond. There's the surety market. You want to go to a bank or do you want to go to a surety? And do you want conditional or on-demand bonds? Well, various types of bonds. There's a bid bond. It guarantees performance at the tender stage. All familiar with that? You put a tender in, you get a bond behind you, say, he'll do this, he really will. Okay. Performance guarantees performance during the construction and defects liability period. Fairly straightforward. You can get a retention bond. They're provided in lieu of a party keeping monies back, so that because they will say you haven't finished the work. RPA bonds, they're used for food importers, basically to guarantee the goods will arrive in fit and proper condition for human consumption, etc. And you can get HMRC and duty deferment bonds, but they're used by importers just in case they paid the wrong amount of tax to the revenue. You can also get an advance payment bond, provided where goods are ordered but payment is deferred until delivery on site. Clearly, that one is particularly important at the moment. Highways Act bond, public works section agreements, guaranteeing roads, sewers, street lighting, etc., will be installed to adoption standard by the local authority. Waste operators license, transfrontier shipment of waste bonds specific to the waste industry, and pension bonds for companies that TUPE staff. There's a lot of that going on at the moment, surprisingly. They have a defined benefit pension. It's a scheme whereby pensions get transferred, etc. You can buy bonds for that. Now, the surety market broadly divides into two areas. Insurers, well, yes, I know, I nearly swore there by saying insurers. HCC, Aviva, QBE, RSA, Zurich, Euler Hermes, Chubb, Liberty, Hiscox, AIG, Markel Travellers. They're all good at providing bonds. They've all got a minimum Standard & Poor's rating of A, so they are not going to go bust. However, we are now in, without any shadow of a doubt, I've been practicing in the insurance market for 32 years, the hardest insurance market I have ever known. There was a bit of a bubble in 2002 after the attacks on the Twin Towers in New York. But since then, we had a review by Lloyd's of its entire market and basically saying to underwriters, do not write business that is not going to produce a profit so you can pay claims, because that affects the solvency margins. The result of that was many insurers pulled out of the market. So there are now fewer insurers providing bonds, and in particular, they are much more stringent now in terms of due diligence, and the costs have increased. Not only was the Lloyd's inquiry, sorry, the Lloyd's action basically reduced the numbers of syndicates who were prepared to offer. We've had the 737 MAX situation. Remember that? The aircraft that didn't quite fly? Boeing built 700 and something of them. That was a big hit on the insurance market. In addition to that, we have significant reserves for the outcome of the Grenfell inquiry. Professional indemnity insurers are very, very worried about that outcome. And then on top of that, we have just recently had the FCA against insurers decision, whereby many insurers who had said that, quote, COVID-19's got nothing to do with me, suddenly find that it is a great deal to do with them. And therefore, premiums in the insurance market are going through the roof. If you can get cover at all. If you mention the word cladding to an insurer now, he runs away. Banks also, of course, offer sureties, HSBC, Lloyds, Barclays, RBS, that way. I'm sure there's others as well. But do not ever, ladies and gentlemen, go to offshore markets. There is no way that I will be able to enforce a bond or in a European country. Well, I may be able to, but it will take a long time. But certainly if you get offered any bonds from Russia, any states like that, Middle Eastern states as well, not the best, no, getting better. Gibraltar is another classic one. Don't go there. It takes you forever to get your money, and they're not worth the paper they're written on. In terms of market share, well, when these talks were prepared, insurers were about 30%, banks 65%, offshore 5%. As I said, not worth it. Don't go. Do your due diligence. If you are looking for sureties, bonds, etc., check out the companies that you're dealing with. Banks typically require 100% through collateral through cash coverage. Sorry. Or charge to support a bond. Surety, the start point is zero collateral. Surety is accepted insolvency risk. I doubt whether they'll be doing that just at the moment. Bank, well, they issued bond wordings, but they are always, as with everything you have to do with banks, it's always on demand. Sure, anyone that signed a personal guarantee with a bank or any form of guarantee with a bank, it will be always on demand. So, take for example the credit crisis in 2007, 2009. Before that, banks were giving out money like it was confetti, but always under their standard terms and conditions. And they could always call it all back on demand. Banks always have on-demand contracts. And banks have lots of money, can afford very expensive lawyers who are entirely ruthless. So don't, well, my advice would be to get one from a bank that says on demand. Sureties, with a few exceptions for certain types of bonds, recommend conditional bond wordings. Much better. Banks have gradually over the years though now started to retreat from surety, but they're still dominating the market, especially in Ireland and in other locations. However, beware of the on demand. It means what it says, on demand. Sureties often have stronger credit ratings and market share is steadily increasing in the UK. In the US, sureties have 90% of the market share. I don't think I need to re-emphasize this point. Conditional contract guarantee bonds, they follow the underlying contract and are triggered by a breach of contract, including insolvency, but that's different to having an on-demand guarantees. On-demand bank guarantees do not follow the contract and can be triggered on the beneficiary's request. Performance bonds, they should be avoided as per the Association of Insurers and the Office of the Deputy Prime Minister. Don't do performance bonds. They really don't work. The best thing to do is have a conditional one. If you are breaching the terms of the contract, they're triggered by that breach of contract. Okay. ABI model bond forms are equitable for all parties, although amendments can be negotiated. Again, you can negotiate what you want into the contract, but once you've agreed it, make sure those terms are finite and definite. Bond information requirements, well, these will be increasing. I have absolutely no doubt. Now, general company information form, yes. Bond application, excuse me, bank information form, bank facility letter, bond wording, budget and forecast accounts, including cash flow forecasts, current order book and pipeline audited report and accounts, management accounts and supporting balance sheet, land and development schedule developers, etc. Increasing because of COVID-19, the risk of insolvency, etc. So please be very careful about what you do. Avoid on demand. In this day and age, ladies and gentlemen, it's not what you want. Make sure that your performance bond or whatever it is follows the terms of the contract. Ah, Julie, did I wake you up there? Sorry.
You did indeed, John. How rude. Okay, thank you for that. If anyone has any questions, please let us know now, as I say, via the Q&A panel. Otherwise, you can pick up the recording of this as well if there's anything you wanted to go over on our YouTube channel at Silver Sherrings Ash on YouTube. And as we said before, John is always available on Jon Sharp, that's Jon Sharp at silverllp.com. Always happy to answer your questions. Thank you very much, John, for your time.
You're very welcome, Julie.
The weather's not too grim up in Scotland, and we will see you.
Well, it's poured down with rain all day, but thanks for asking.
Okay. All right. Thank you, John. And thanks everyone for joining us. We'll see you all again soon. Thank you.
Thank you.